Welcome back. Today we're going to be talking about estate planning, but more specifically picking a trustee, right? Like how do you
Correct.
pick a good trustee?
Mm-hmm.
Oftentimes, like when I've reviewed people's trust documents, they pick like a family friend that maybe they're same age as them or
Mm-hmm.
older,
Yeah.
and that could sometimes be problematic. Would you agree?
Correct. Yeah. So what I will typically see is people tend to default to either family members or friends. And those individuals are, while familiar with the family dynamic, are maybe not the best suited to act as either a trustee, an executor, or an attorney in fact under a financial power of attorney.
Yeah.
Or I'll meet with clients who are starting from scratch and say, "Hey, who do you typically see as far as a successor trustee, and what are our options?" So we'll walk through that a lot with clients in the
So
introductory
let's do
meetings.
that. So like in my mind, there's like two or three people, right?
Mm-hmm.
Like so you could have a family member.
Mm-hmm.
Um, but what are some of the other options? I guess a bank could step in to be a trustee.
Correct. A bank that has a trust division inside the bank could be a trustee.
Yeah.
Correct.
What else?
And then we also see private fiduciaries.
Hmm.
So there are individuals out there who, based on their background, have decided to make a career out of being a fiduciary. And there are certain ones here in town who we do a lot of work with, but that is an option as well.
Okay. So from closeness to family, you have family and friends being the first layer. Then you probably have this private fiduciary or professional fiduciary as a second layer.
Correct.
And then probably the furthest out would probably be the bank, right? So
Correct.
let's maybe talk some pros and cons about each one. So like family, they know you,
Yes.
right?
Yes.
Like they know.
They're familiar with the family situation, and that can be a pro, but it can also be a con, honestly. So, obviously it'll change the dynamic depending on what trust provisions you have in place. You have a daughter who has spendthrift issues, and you want all of her assets in trust, and you're going to appoint her brother as trustee. That's great
because dynamics.
The brother knows his sister, but it can also create a rift in the family situation because it changes from being purely family to being more of a monetary situation. And so sometimes it works out okay, and the family members having that family knowledge is great. We're also just being a part of the family dynamic. So you've had conversations with that person as far as what are their preferences, what are their wants and desires for those children. That can be helpful, but it can also be a con. Also with family members and friends, they're mortal. So you put a person in place depending on their age, their health situation. They may be the perfect fit right now, but the goal with estate planning is you're going to put something in place and maybe not look at it for a few more years.
Yeah, and there could be situations where what if that person gets sick or that person's unable to serve as a successor trustee?
Correct.
Then what happens? I guess there's another person that they could appoint, or there's a second backup?
Correct. So it'll depend on the trust document itself. So if they have multiple people who they'd like to list, we'll do that. As a minimum, if they have only one person who they would like to appoint, we'll give that person the ability to appoint his or her successor. So you created this trust, you've passed away, this person has health issues, financial issues, they just simply don't want to do it, we'll give them the ability to appoint their successors.
Well, that's good. So it's not just one successor. You may need a backstop.
Correct. We tend to like to see at least multiples listed, or at least who can appoint the person, fill the vacancy if there is one unforeseen.
And so the pros of family members is they know the family dynamics better than probably anybody else, but then they're also part of the family dynamics, right?
Correct. That can be a con.
And so the next one is a professional fiduciary.
Yeah. So professional or private fiduciaries that go by either term. So again, those tend to be individuals who were accountants, attorneys, financial advisors who are involved kind of in this area, but have since decided to make it their job to act as a fiduciary, hoping to kind of fill the gap between a corporate institutional fiduciary and a family member or friend, because again, they are knowledgeable about the process. They do have a background that is appropriate for doing trust administrations or probate administrations. A pro that we didn't talk about with family members is they tend to be cheaper than an institutional or a corporate trustee. Sometimes they'll even waive compensation. So they're cheap, but they may not know what they're doing. A private fiduciary will have a fee schedule in place, but they tend to be a little bit more flexible as far as what they charge as opposed to a corporate trustee.
Right. So like a family member may have not dealt with wealth. Mm-hmm. They may not have the ability to manage. They could be working. I just think of this as like, if you have mom and dad here, children here, children could be in their peak earning years, means high stress jobs, no time,
busy family
they
life.
Have
young children. Do they want to be or do parents want to saddle their kids with trying to figure this out? Mm-hmm. So again, it tends to be people more of the parents' generation who they designate, or if they can, the next generation. It's also important with an individual is they don't need to necessarily be well-versed in how to invest or what a probate administration involves or what a trust administration involves. They need to be fiscally responsible at a minimum, but knowledgeable enough to know they don't know what they're doing. So they need to hire a lawyer, they need to hire an accountant, and they need to hire a financial advisor. Yeah. And the trust will pay for all of those agents or advisors for the trustee.
And so it could be like a co-trustee type relationship where where you could have a professional and a family member be part of the trust documents.
So you could do it as a co-trusteeship or even just an informal, I, trustee, am hiring Wells Fargo Bank to assist me in investments or Fidelity or whoever it may be, but not in a co-trusteeship role necessarily, but more in a financial investment advisory role.
I see what you're saying now.
And that will be a cost and expense of the trust. Same with an attorney. So I work with a ton of successor trustees who now have the job of fulfilling the trust requirements and don't know what's involved, don't know what's required.
And so they have to get an attorney to help. Right. Okay. Now that makes sense.
To assist them in that process. So you want someone who knows what they know and understands what they don't know and hires the right people to help them.
And I know like in California, the attorney that drafts your documents shouldn't really be your trustee as well, right? Is there some sort of conflict? Like, can you explain that?
So you will sometimes see attorneys who have drafted the document also listing either themselves or their law firm as a successor trustee in the documents. And the California Probate Code has provisions in place dealing with compensation. And so there is a self-dealing element because the trustee is going to get compensation as well as the attorney for his or her legal fees.
Yes,
and so like that's a double compensation. Yeah.
That's bad.
So the California legislature has dealt with that, and there is a probate code provision in place. It's basically you need to provide notice to all the beneficiaries of this kind of potential conflict of interest. I know in my practice, I don't act as a trustee. My role at this stage in my career is only as an attorney. And I have been asked by clients to act as a trustee, and I will typically decline unless it's a really unique situation. I have in the past given myself the power to appoint a successor trustee.
Oh, so that's interesting.
But for the exact reason you noted, it's much better to have clearly defined roles. Am I the attorney or am I the trustee? And to not blend those, in my opinion.
Yeah. And so now we're going one layer away from the family. It would be like a corporate trustee.
Yes.
And this is like a bank, you said.
Correct.
Right?
Yeah.
Could anybody else serve as a corporate trustee besides a bank? Like,
so a trust company could.
trust company,
so,
right?
Correct. Yeah. So as long as they are authorized to do trust business here in the state of California, they can act as kind of an institutional or corporate trustee. So a lot of the kind of big banks that you think of do have trust divisions or trust companies associated with them. But there are some institutional trustees that do not handle the investment side. They only act as a fiduciary.
Okay.
They're unique. You don't see them as much.
Yeah. So there could be certain things, like a bank wouldn't want to deal with real estate, right?
Correct.
For example, if you had
Correct.
Commercial property or rental property or whatever it may be, the bank doesn't have time to find tenants, et cetera. So
Correct.
So that would be something that you would have to kind of talk through to make sure
Correct.
that.
And a lot of corporate trustees have provisions that they want to see put in the trust document, and those provisions typically will include kind of special asset provisions. So you have Fidelity Trust Company that's acting as trustee. They're based in New Hampshire. They don't want to deal with California real property.
Yeah.
So there's going to be provisions in place saying, to the extent there are trust assets that are California residential real property, we will not be the trustee of that. A special trustee will need to be appointed. So it is important for clients to kind of walk through, what are your assets? What are your goals for those assets at your death? Because if the goal is to liquidate everything, then, and it's just going to be investment assets anyways, then a corporate fiduciary is probably fine.
Yeah,
but if you have, a gas station, that's located here, no corporate bank is going to want to act as trustee with all the environmental issues.
Especially in California.
They're
going to
say,
horrible.
No, thank you. And then you're in a terrible situation where you suddenly have a vacancy. You worked so hard to put the right fiduciary in place, and that fiduciary doesn't want to act.
Yeah. So it's very, there needs to be like a kind of like a full conversation of capabilities from each aspect of a corporate trustee. And I think like one of the other things we should talk about is like, what are some of the negatives of corporate trustees? And I think from my experience that I don't want to call it individuals that are beneficiaries of trust finding a new way to get money, but if a corporate trustee pushes back on a beneficiary saying, hey, we're not going to give you money for doing X, Y, and Z because it's not written in the trust, there could be some provisions in the trust that beneficiary can find a new trustee, right? So then they could go to another bank. And when you go to another bank, that bank is looking for new business, and they could.
They'll say, sure, we'll make that distribution for you. So it's bank shopping or trustee shopping. And so we will see that sometimes, certainly, where you have worked to appoint an institutional trustee. That institutional trustee will have certain procedures in place and steps that need to be fulfilled before making distributions. And a beneficiary could get frustrated or just upset with the process. And so depending on what the trust provides, the beneficiary may have the right to remove that corporate trustee and appoint a successor institutional trustee. And you can find all sorts of banks out there who are willing to
go trustee shopping, right? Like you said. So like you go, there's a row here in San Diego where there's a whole bunch of banks, and you could just go one to the next to the next until you find somebody that would say yes. Right.
So what we will do sometimes in our trust documents is we will say, yes, beneficiary can remove an institutional trustee and appoint a successor, but they can only do that every 2 years. Or every 3 years. So they're not constantly churning through banks who are simply unwilling to basically go around the trust terms and make distributions for any reasons.
Perfect.
So we can build provisions in place dealing with that.
Yeah. So when we look at this, the closest is family. They know your family dynamics. And then we go to professional or private fiduciary, and then we go corporate. How do you pick the right person? Like, so like, do you have like a top 5 of like how you'd pick a right trustee? So in terms of qualifications and then the ability to do it.
Correct. Yeah. So so who the successor trustee is going to be is always a huge part of the conversation that I have with clients. And it is always based on what are the assets and what are the trust provisions. So again, if the goal is to liquidate everything and just an outright distribution to the kids, then having a family member in place to do that may be appropriate, because based on the trust administration, it's going to be simple. It's going to maybe take a year.
And it's pretty clear what the family wants, right? There's no ongoing or complexity or anything like that.
So there you can build in probably relatively simple and straightforward successor trustee provisions. If you have complicated assets, you have a complicated family situation, then the conversation becomes much more involved and kind of walking through what the various options are. Because on the one hand, a corporate may be perfect because you have a really complicated asset structure. Your estate is worth $50 million and an individual can't deal with that. On the other hand, depending on the type of assets you have, a corporate may not be ideal. Or you have a beneficiary with severe substance abuse problems, a corporate fiduciary may not be appropriate on that. So we try and walk through as I'm talking about what their assets are and what the trust distribution provisions are going to be. And we have that conversation along those same lines as far as who's going to manage this. Because I think that's a critical part of the question is, what are the assets and what are the trust provisions?
Yeah, and part of that also is, what if your family's part of your family business, right? And you choose somebody to run the business, and so there's family dynamics aspects of that.
Can they, as trustee, force a sale of that asset? And it changes things. So the control aspect is a huge part of this. And again, if the goal is to everyone move on once you die, it's not going to be a continuing business, then fine, the analysis can be different. But if it's an ongoing venture that multiple family members are involved in, then maybe having a neutral party who has procedures in place, who deals with this on a regular basis is better, or maybe worse than having a family member.
And so what about proximity to family? So I know, I've had clients where they've chosen the children have changed jobs and moved around. It may not be local anymore.
Correct.
Is being local as important as it used to be?
So I would say it's not as important as it used to be. So there are certain circumstances where you want someone boots on the ground. I would say an advanced healthcare directive and who's making your healthcare decisions, that's someone who you want in close proximity or who is very reachable, because that can be like an emergency medical situation where decisions need to be made quickly. On the fiduciary, the trustee side, the will side, you're seeing much more remote abilities these days with technology. You can Skype, you can have phone calls, you can have emails, and it's not as critical, I find, to have the fiduciary here. But, again, part of the question is this an ongoing trust administration? Where are the beneficiaries at? If you have beneficiaries here and they require a lot of face-to-face meetings because of that dynamic, then having someone who lives in New York may not be ideal.
Yeah, it might not be ideal at all.
But it may be what suits the situation best.
Yeah.
So, but I represent a ton of clients who are not here, but they were listed as the successor trustees on their parents' trust, their brother's trust, their sister's trust. And so they now have come in and I work with them because I'm here. So I can sometimes, or you as the financial advisor, we can sometimes fill the gap so that we're here with the local people and they can manage the business remotely because they have advisors locally.
Right.
But I find that's much less of a concern than it used to be for everything other than maybe healthcare decisions.
Yeah, so technology has really helped get business done virtually, like we're doing this on YouTube and podcasts.
Yeah.
But
even filing court documents, not too long ago, you could not file electronically. Now you don't even really need original signatures on court filings. filings. You
Oh, so
can,
that's,
yeah, I represent a woman right now who's in Canada, and she was just emailing me yesterday saying, I need the original signatures, but I can get it on file with the court electronically. And so technology, the court's catching up slowly.
Right.
But,
like anything government related, it takes like another decade or two.
But I represent a ton of people who are not.
So they would just like sign it, scan it, send it to you, and then you can start the process. And they'll snail mail the regular documents.
They'll FedEx me the original signature page, so I have them for my record. But the court, we can file things electronically now. So I do court matters in Los Angeles. I do court matters in San Francisco. And with the hope that I can call in as opposed to making a personal appearance. So things have changed a little bit.
So if you're looking at a trustee and let's say you're in your 80s, your children are at peak working years. So we talked about that, but like, so what age range is a good trustee relative to your own age range, right? Because it can't be, your brother was like also in their 80s, right?
Yeah.
So like it could be niece, nephew, sibling, or like
I see. I mean, it really runs the gamut. I met with clients recently who they wanted to list their 2 kids as successor trustees, and one was 22 and one was 18. And I said, wow, really? And they're both in college. I mean, so even just they're busy with college schedules, they're young. And they said, nope. And I walked through everything with them so part of my role is playing devil's advocate. Let me throw out every scenario to you so that you're going in eyes wide open. And at the end of the conversation, they said, thank you, but we still want to go with our children. That's unusual. And then it's unusual to see the 80-year-old family member or friend acting as trustee. It tends to be somewhere in the middle. But as you noted, ages 30 to 60, that's when people are still busy with family, with careers, with earnings, and may decide that they don't want to do it. So I think part of it is having a conversation with who you're thinking about and saying, hey, I'm in the process of doing my estate plan. I'm exploring successor trustee options. Would you be interested? Or you do a co-trusteeship. So that's the other way that you can do it, is you have 2 people or an individual and a bank, and you basically divvy up the roles. You divvy up the activities so that you're all aware of what's going on and a part of the decision making, but you don't have to be at the bank together to set up a trust account or, whatever the business, the day-to-day business, you can kind of divide that among the various trustees. So that would be an option as well, as you have kind of a co-trusteeship or a corporate and an individual with the hopes that they're kind of dividing up the tasks.
That's great. So we went over knowledge, age, closeness to the family dynamics. Is there anything else you'd like to add in terms of how do you find the right trustee for your family?
Yeah. So again, I think it's constantly reviewing who you've designated is critical as well. So again, part of it is that person is going to work great right now, or the bank is perfect for right now, but that may not always be the case. So kind of always reviewing your documents. And we typically recommend every 2 to 5 years or anytime there's a big life change. So review, just making
just
sure
constantly update,
that person.
Review.
So what I hate seeing is when they don't have the perfect person or solution for the next 20 years, it stalls the process entirely. That's not good. You still need a plan in place, knowing that you're going to be reviewing it over time and making sure they're still well suited for it, because your child may be 25 right now. The next time you review it, they may be in a different place and they may be the appropriate person at that point in time. So finding the right person for now, knowing that you're going to be reviewing it over time, is critical as well. So
that's great. So if anybody wants to reach you or have trustee type questions, how do they get a hold of you?
So you can find all my contact information and my bio on our website, which is smalawsd.com. I understand our contact information will also be at the end of this podcast, but feel free to email me, call me with any questions. I'm happy to help.
Thank you.
Thanks.
Thank you for listening to the Savvy Wealth Podcast. Click the subscribe button below to be notified when new episodes become available. The opinions expressed in this program are for general informational purposes only and are not intended to provide specific advice or recommendations for any individual or on any specific security. It is only intended to provide education about the financial industry. To determine which investments may be appropriate for you, consult your financial advisor prior to investing. Any past performance discussed during this program is no guarantee of future results. Any indices referenced for comparison are unmanaged and cannot be invested into directly. As always, please remember, investing involves risk and possible loss of principal capital. Please seek advice from a licensed professional. Client First Capital LLC is a registered investment advisor. Advisory services are only offered to clients or prospective clients where Client First Capital LLC and its representatives are properly licensed or exempt from licensure. No advice may be rendered by Client First Capital LLC unless a client service agreement is in place.